All right, I think we will get underway. Welcome, everyone, to the first of what we anticipate will be a good deal, a great many public meetings and opportunities for you to learn more about the work of the Office of Cannabis Management. Before we get started and do a quick round of introductions, if you are logged on but having some difficulty with audio or other tech support issues, the information on your screen, you can email the nature of your issue, or you can call the number. I would suggest that it is a little easier and more efficient to email, and you'll be able to get some tech support. If after that you're still not able to access this, fear not. We will be posting this once we process the recording. We're recording it and we'll be processing it for accessibility and posting it on the Office of Cannabis Management website shortly. I'm Charlene Briner. I have the privilege of being in a position of leading this adventure of the new Office of Cannabis Management. I am the implementation director, which simply means that I am helping put some of the early pieces together. I'm joined tonight by several colleagues, including Chris Focus, who is currently the Director of Medical Cannabis at the Minnesota Department of Health. She'll be talking to us about the temporary regulations that the Department of Health and the Office of Medical Cannabis is in charge of as of August 1st. And I'm also joined by Chris McNulty, who is the Deputy General Counsel at the Minnesota Department of Agriculture and is also leading in these early implementation stages our work around rulemaking, which I know many of you have an interest in. So we're going to start with the basics. What we hope to do tonight is just sort of run through some of the work that we are doing. There's a lot of behind the scenes work happening that people are curious about and that is not visible to the public. We thought it would be helpful for folks to understand what we're doing to actually put this in place. So let's start with the basics. As of August 1st, full decriminalization went into effect. You've probably read and seen about the personal possession and home grow limits, 2 ounces of flower in public, 2 pounds of flower in a private residence, 8 grams of cannabis concentrate, the edible product limitations of up to 800 milligrams of THC, home grow of up to 8 plants in total with no more than 4 of those being fully mature at any given time, and the allowance for paraphernalia. What does it mean to think about early implementation when we're building an agency from the ground up? This is something that is relatively rare in state government. Usually, the agencies that we're familiar with have been in existence for a long time. We may have leaders come and enter and make changes, but this is really a unique opportunity for us to assess the business needs, to evaluate the authorities that the legislature and the governor have given to the Office of Cannabis Management, and then to meet those business needs in a way that really helps us ensure the success of the cannabis industry in Minnesota. So it's important to know that the Minnesota Department of Agriculture is serving as the incubator agency for standing up this office. What that means is we have access to a tremendous amount of resource here at the department. We have access to obviously Chris McNulty and legal advice around rulemaking. We have access to some of the experts in human resources and finances who are helping us build a budget and write some of the early positions that we're going to need to post. It also means that we need to identify a director. I have been tasked with guiding the search on behalf of Governor Walz to identify that new director of the Office of Cannabis Management. That means writing the job position and posting it, casting a wide net in the recruiting process, leading a multi-phase screening and interview process. And we anticipate sending finalists to Governor Walz in late August, and he expects to make an announcement in early September about who that new leader will be. In addition to the director role, we're also drafting and getting ready to post some of our first key leadership positions. Our intention is to post those positions later this month. So at the end of August, you'll see 8 to 10 key positions posted. And the goal is that there will be a portfolio of applicants, qualified candidates for the new director to begin interviewing and hiring and building out that team as soon as they get on the job. As soon as is a relative term, because they're going to be inundated with a whole lot of work when they take the reins whenever they're able to start. And then we're also working to fill out the Cannabis Advisory Council. There is a 51-member advisory council in statute that has a wide swath of experience. It calls for people with experience in public health, experience in the industry, experience as a medical cannabis patient or the family of a medical cannabis patient, and any number of positions. Those vacancies were posted in July. The Governor's Office of Boards and Commissions is leading that screening, vetting, and notification process. And Governor Walz expects to name members in fall of 2023 at some point after the director has been appointed. I would note it's really important for folks to know that even though those vacancies were posted in July, there is no deadline for applying. Applications are screened on a rolling basis. And so some of you in the audience may have interest in serving on that council. I would encourage you to apply. You can go either to the Minnesota Secretary of State's office to look at those vacancies, or there is a link to that online application and information about the appointments on the OCM website. I would encourage you, if you are interested, to submit an application sooner rather than later, since that screening process has already started. Some additional work that we're doing outside of those three primary buckets. In order to implement, we've identified a whole lot of work streams and a whole lot of specific activity that needs to happen, not the least of which is communications, engagement, and outreach. There is a tremendous hunger for information about what this will look like, about how we're going to go about rulemaking. There is interest from people who are interested in starting a business and want to know what they can expect. And so we're trying to be very proactive as much as possible. To provide external communications. We're constantly updating our website and providing information. And so again, I would encourage you to continue to check it often. Obviously, we've created an implementation team around rulemaking. It doesn't mean that Chris McNulty is doing this on his own. We are also consulting with legal and rulemaking experts from other agencies. We are also in the process of securing a contract to build and to design and build our licensing system. We know that we need to have a seed to sale licensing system that is both easy to navigate and access for people who are interested in a business license, and that is also easy to navigate for those of us who will be charged of administering that licensing system. So we're in the process of finalizing that contract and expect to have that in place relatively soon. We're also thinking about the operational aspects. So we have an implementation team solely tasked for operations, which includes, as I mentioned, finance and human resources, but also facilities. We have sister agencies who might be able to house some of the early staff temporarily, but I don't think that there's any agency that has the capacity to take on a 100 to 150 person agency. And then, of course, building and figuring out the IT systems we need to actually do the work once the office is fully standing up. And then, of course, Chris Tokas will be talking to us about the temporary regulations that will be that are in place as of August 1st. We're filling out those job descriptions. As I said, we're going to be posting in August. We're going to launch rulemaking later in the fall. We're thinking about procurement and what we'll need to actually have a functioning office, and then ultimately preparing for applications and licensing upon the completion of rulemaking. Some additional background that is important, and as we were thinking about this presentation and the information that people would be curious about, we thought it might be helpful, and we've sort of tried to do this as we put this presentation together. What stays the same? What is in transition? So what's temporary or transitional? And then what's ahead as we think a little further out beyond this transitional period? So what stays the same is Minnesota's hemp program. The Department of Agriculture will continue to administer and regulate Minnesota's hemp program. What stays the same is Minnesota's medical cannabis program. One of our core principles is to minimize and avoid any disruption or access to medical cannabis patients. Eventually, that program will move to the Office of Cannabis Management, but not until March of 2025. And so for now, there is no change to Minnesota's medical cannabis program. And even once it migrates over, we're still going to be, you're going to be dealing with the same team, the same staff. It's really kind of picking them up and transferring them over to the larger umbrella of OCM. Lower potency hemp products continue to be available. That does not change. What does change, and Chris will be talking a little bit more about this, is the oversight has moved from the Board of Pharmacy to the Department of Health and to the Medical Cannabis Office. Those temporary regulations went into effect on August 1st and will continue through the time that the Office of Medical Cannabis moves to the Office of Cannabis Management in March of 2025. And then some other considerations or additional background. This is not just the work of the Office of Cannabis Management or the Department of Agriculture or the Department of Health. We have multiple intersections and interactions with agencies throughout the state government enterprise. Everything from the expungement process, which will take place at the BCA with the Department of Public Safety, the new cannabis tax that went into effect on July 1st at the Department of Revenue. We're working with the Commerce Department around interstate banking issues and really trying to figure out how best to support people to understand the banking laws and how they can access information given the federal status of cannabis. And the knowledge that banks are somewhat reluctant to enter this space. And then the local authority for enforcement during this period of transition. One of the interesting pieces of this law is the decision that was made to decriminalize on August 1st in advance of having in-force administrative rules. I think that the thinking was that the state made the determination that this is not activity that should be criminal any longer, and so it is better to stop that criminalization even though we wouldn't be in a position to stand up a retail market until rules are in place. And so, as you can imagine, there are lots of conversations that the implementation is having with folks across the state government enterprise in work streams related to their specific expertise and knowledge. This really is an all hands on deck endeavor, and I am really pleased to say that folks have been excited, eager to step into the space, and have offered a wealth of information and resource and knowledge to us. I wanted to take a moment just to talk a little bit about Minnesota's tribal nations in the cannabis space. So as sovereign nations, Minnesota's tribes determine and have always had the ability to determine how to regulate and oversee cannabis businesses on tribal lands. Minnesota's cannabis law is among the strongest in the nation to honor and recognize the sovereignty of Minnesota's tribal nations. And so we think that is an important piece of it. And as you have read in the news or read or seen in the news, both Red Lake and White Earth have open dispensaries on tribal lands. We believe that there is a lot that we can learn during our rulemaking process about what's worked well on the tribes, how they are enforcing, regulating, and operating. And so it is a really important piece of our overall thinking to watch how tribes are succeeding with the early foray into this business. It is also important to know that Minnesota's tribal nations have the ability, the law gives the ability for tribal nations and Governor Walz to enter into a compact. What that means, a compact is actually an agreement that determines the parameters for tribal nations to operate cannabis businesses outside of tribal lands. There are several tribes who have expressed interest. We have not yet formally begun that compacting process because the last time the state actually created compacts was about 30 years ago when the gaming compacts went into effect. And so we're doing the preliminary work to prepare for those conversations with tribes who have expressed interest. And I would say that there are several who have expressed interest and are also very intentional about making sure that the agreements will be consistent with expectations that will be in place once we complete rulemaking, because our goal is a safe, regulated, accessible market with consistent standards so that consumers know what the product contains and what they're purchasing. And so everybody has a shared interest in that. Key dates of interest. I'm not going to read all of these, and I'm going to actually skip quickly over this first one. Our key dates of interest are also on the website. We've passed all of these milestones from the day that Governor Walz signed the bill on May 30th up through July 31st. We did some preliminary work. We started issuing seed permits at the Department of Agriculture. The cannabis tax began. The enrollment fee for medical cannabis patients. You can read it for yourself, but we passed a number of milestones. And as we look ahead from August 1st, when full decriminalization went into effect, we're continuing with some of the work that I've discussed in the previous slides. So looking for and finalizing, Governor Walz will be finalizing and making his announcement about the Office of Cannabis Management Director. We'll be launching rulemaking in the fall of 2023. Chris Thokus will be talking about the registration process for hemp-derived edible products and topicals. We'll continue throughout 2024 with rulemaking on a variety of topics. And then in early 2025, we anticipate license applications to be available for people who are interested in securing one. Finally, kind of the implementation work will conclude with that final transition of the Office of Medical Cannabis to the Office of Cannabis Management. And then finally, I wanted to talk about some of the provisions in the bill that will be the purview either of the Office of Cannabis Management or that will actually will be in a consultative and partnership role. So the Can Renew grants are some grants that have gotten some attention around reinvesting in communities that have been disproportionately impacted by the criminalization of cannabis. So everything from grants to nonprofits to education and outreach efforts, violence prevention, and public health efforts. We'll be collaborating. Those grants, the Can Renew grants, will be administered by the Office of Cannabis Management. There are some additional grants, and actually it says DHS on here, but we believe it actually will be the purview in consultation with the Department of Human Services and the Department of Health to expend substance use treatment, recovery, and prevention grants. So we'll be working closely with sister agencies on that work. There are efforts to prevent youth cannabis use, and there are education and outreach campaigns directly targeted to young people to make sure that they don't get the impression that cannabis is okay just because it's okay for adults. In the same way we work aggressively to prevent tobacco and alcohol use among teenagers, we want to do the same work to prevent cannabis use by people under the age of 21. And then education to women who may be pregnant, who are pregnant, maybe become pregnant, or are breastfeeding, to make sure that they fully understand the risks of cannabis consumption if they are pregnant or planning to be. We're going to be doing training, and that's going to be the purview of the Department of Health for family home visiting. There are going to be grants to local and tribal health organizations administered by the Department of Health. And then one of the exciting things is the dual training pipeline at the Department of Labor and Industry. So what we know, in order for the cannabis business to succeed and to thrive, we need to build a bench. And so the dual training pipeline program has now added cannabis as a program area. And it's really designed to help us build that bench of future cannabis workforce. And then finally, I'm going to wrap up my time with that really quick and broad overview. Here are resources you can continue to refer to. And I would, again, encourage you to check the website because we're adding information and resources all the time. You can also see resources at other agencies that you can avail yourself of. And just know that we are in a constant process of trying to be as proactive as possible in getting information to people who are curious. We also know there's a lot of questions you have that we don't have answers to yet. But that's going to be part of the process. You're going to have a role to play. Everybody listening has a role to play as we begin rulemaking, because what we know is that in the same way that the bill was passed due to advocacy, partnership, and the best thinking of people with a vested interest in this industry, that creating those rules will depend on working alongside people who have expertise and knowledge and can inform us in that process. So with that, I'm going to turn it over to my colleague, Chris Thokas, and I will see you again a little later in the presentation.
Hey. Okay, good evening, everyone. I'm Chris Thokas. I am the director for the Office of Medical Cannabis, and I'm going to talk tonight about the temporary regulations for the hemp-derived edible cannabinoids. So these are the products that have been around for some time now. So we're talking about Minnesota Statute 151.72, the sale of certain cannabinoid products. It includes edibles, beverages, and topicals. The regulatory authority for these products used to be at the Board of Pharmacy and has now moved to the Minnesota Department of Health and is in my division, the Medical Cannabis Division, where we are standing up a new unit of staff just to focus on regulating these particular products. The temporary regs are in effect until the Office of Cannabis Management begins actual licensing for these products, which we expect to be in March 2025. We are talking about compliant. We're going to go through a list of what we would consider compliant products and then non-compliant products and such. So what we consider to be compliant products are the edibles and beverages, no more than 5 milligrams of total THC per serving. This would include edibles, would be a maximum of 50 milligrams in a package. This would include edible oils. We're going to talk just a little bit about the difference between what some folks are labeling tinctures and what would be considered an edible oil. Beverages can contain a maximum of 2 servings per container, or 10 milligrams of total THC. These products may only be sold to people ages 21 and up. These edibles must be placed in a locked case or behind the counter. That is for the edible products. That's not required for beverages, and it's not required for topicals to be locked up. We're also going to talk a little bit about hemp flower. We're seeing quite a bit of hemp flower for sale out across the state. Minnesota Statute 151.72 applies only to hemp-derived cannabinoids. So the raw, unprocessed material and products are not included in the temporary regulations. Raw hemp flower from a certified hemp plant, which means THC concentration of 0.3% dry weight or less, can be sold. Flower with THC content above that 0.3% is considered marijuana, and it falls under the jurisdiction of local law enforcement authority. So looking a bit to non-compliant products, the things that are no longer considered compliant products are vapes, tinctures, and we see a lot of folks labeling liquids as tinctures. A tincture is a compound that is dissolved in alcohol. So tinctures, as a true tincture, are not allowed. Edible oils, which contain a food product as an ingredient, would be a compliant product. Capsules are a non-compliant product. Raw flower, which has CBD or THC applied to it, non-compliant. Any products that exceed the 5 milligrams THC per serving or 50 milligrams per package, non-compliant. Edibles, which servings cannot be distinguished. So the edible products, they have to be scored or individually wrapped in the 5 milligram servings to be compliant. And then beverages that contain more than 10 milligrams total THC in 2 or more servings, also non-compliant. Marketing towards children. So talking a little bit about marketing, strictly prohibited to market these products towards children. So the components that reflect that are that edibles cannot be in the shape of a fruit, animal, cartoon, or a real or fictional person. Edibles cannot be modeled after a brand product primarily consumed by children. They cannot be made by applying THC or CBD to a commercially available candy or snack food. They cannot be substantively similar to beef, poultry, or dairy products. Edibles cannot be packaged in a way which would mislead any person to believe the package contains anything other than a THC edible. And edibles cannot be packaged in a way which resembles a commercially available product. So the timeline for the temporary regulations, the regulations became effective on May 31st. Our office began inspections on July 31st. We also have registration that is required for anyone that is selling these products to consumers. So anyone selling the products to consumers must be registered with the Department of Health no later than October 1st. Registration is open now. It's on our website. That registration opened on August 1st. As of this morning, we had a little over 500 folks that have already registered with us. And just from being out in the field a bit with our inspectors, we know that there's many, many more that need to be registered. So I would recommend registering early. As Charlene talked about, the Office of Cannabis Management, it will be issuing licenses. There's a lot of work to be done in configuring the software system and determining the rules, and all of that needs to be in place to get the applications and licensing stood up. So there's a little bit of a TBD on that timeline. And then, as Charlene also mentioned, on March 1st of 2025 is when MDH's authority ends and the Office of Cannabis Management begins. And that is when the Office of Medical Cannabis, which includes the unit that is overseeing regulation of these particular products, all moves over from the Department of Health to the Office of Cannabis Management. So I talked a little bit about the registration, what we are seeing and the types of businesses that are registering right now. We're seeing just a real variety of types of establishments. So of course, exclusive liquor stores, smoke shops or tobacco shops, restaurants, bars, standalone kind of hemp or CBD edible cannabinoid stores. We're seeing breweries, distilleries, convenience stores, grocery stores, beauty, nail salons, barber shops, pet food stores, and veterinarians. Just that's not a comprehensive list, but it kind of gives you a bit of a flavor of who we are seeing register as retailers of these products. So as we go out and do inspections, we are, building out our team. Right now we have an inspector that is able to get out in the field and do some visits. We have written position descriptions for additional inspectors, for a unit supervisor, and a few other positions. Those we expect to be posted. I think some of them will be posted possibly yet this week, if not next week. And so we're hoping to really build out that unit in pretty quick order. The focus of our inspections, we're going out, we're taking a look at, the THC per serving and the THC total per package, looking at non-compliant products, non-compliant forms of THC. So talking about HHC, PHCP, THCO, looking at the product labels and labeling, product packaging, and product placement. Those are kind of our focus areas as we go out and do these initial inspections. The intent or the kind of inspection philosophy as we get out in the field in these initial visits is really to have conversations with the retailers, talk about what makes a product in their store compliant or not compliant, and what they would need to do to get that product into compliance. Or if it's not a product that can be brought into compliance, like getting it in a locked case or something like that, how to destroy the product or what other steps they need to take to remove those non-compliant products. So at this point, we will be issuing correction orders, which is essentially a letter that lets you know what we found that was non-compliant and how you can get into compliance. So we are supporting compliance through the inspections and through our guidance, those correction orders that I just mentioned. We will be re-inspecting following the correction orders. So we'll give folks instructions and then we'll go back out and take a look and make sure that everything's in order. And then, eventually there are other tools that our office can leverage if needed. So we do have embargo authority. We do have administrative penalty orders that can be issued up to $10,000 per occurrence. And there are cease and desist orders. And like I said, those are not tools that we intend to use in our initial visits out to have conversations with folks, but those are tools that we have in our toolbox if needed at a later time. So similar to Charlene, I'm sharing some additional tools that we have available for folks. So our website at the health department has an edible section, a hemp-derived product section where we are continuing to update our frequently asked questions. We have a fact sheet available. There is a link to the registration form where folks can get registered. It's a very straightforward form. It is online. It's really basic information of, your business name, the owner, contact information, what products you're selling. And this list will really be the basis for our outreach going forward and informing folks about the licensing process when we have those details available. And then we do have an email box available for questions as well. So the health.hempedibles@state.mn.us. We were getting a lot of questions every day. We're right around 10 to 20 questions a day at this point of folks just looking for some clarification, and we're happy to continue to take questions in that manner. So at this time, I will turn things over to my colleague, Chris McNulty.
Thank you very much, Chris. As mentioned already, my name is Chris McNulty. I am the Deputy General Counsel for the Minnesota Department of Agriculture, and I am assisting with legal issues, including rulemaking for the new cannabis law. And so to begin with, and I apologize at the outset for some of the technical talk. I am a lawyer, so I can't really help it too much. I think the best place to start here is really, what is a rule? We're talking about rulemaking. Well, a rule is defined in law as every agency statement of general applicability and future effect adopted to implement or make specific the law enforced or administered by that agency or to govern its organization or procedure. And what this means essentially is that rules are legal requirements created by agencies in order to regulate the laws under that agency's authority. And because rules have the force of law, agencies aren't permitted to put them into effect unless they A, have been given the authority to draft the rules by the legislature, and B, the rulemaking process meets various requirements outlined in law. And that law is the Administrative Procedure Act, which includes provisions on required public notice, opportunity for public comment, and judicial review. If the agency misses any of those required steps in the process, or if the rules proposed by the agency exceed or conflict with the legislative delegation of rulemaking authority, an administrative law judge, or ALJ or judge, will invalidate the rules before they ever go into effect. Excuse me. So an obvious question at this point would be, why do we use rules at all? Why doesn't the legislature just put everything into the law? Well, usually the legislature enacts basic policy in the form of the law, otherwise known as a statute, and permits or requires an agency to adopt rules to implement or clarify the details of that law. The typical reasons for delegating rulemaking authority to a state agency are that the legislature typically doesn't have the time in the legislative session, which is fairly short, or the expertise to deal with all the aspects of a topic that they are drafting policy for. So what does this all mean in practical terms? Well, generally speaking, government agencies can only regulate matters which they have legal authority to regulate. So anytime an agency issues a requirement or threatens a penalty for non-compliance, such as a fine or a suspension of a license, the agency must derive that authority from a law, rule, or executive order. If an agency penalizes a business without proper authority, it may be considered unapproved or unpromulgated rulemaking, and the agency action is subject to judicial challenge. It might get struck down. For instance, if there's nothing in law or in a rule specifying what color carpets must be used inside a cannabis business, the Office of Cannabis Management, which I'll refer to probably from here on out as OCM, cannot suspend the business's license for using a green carpet. The authority doesn't exist. That said, an agency may issue guidelines, suggestions, or best practices at its discretion and without going through any formalized legal process, as long as those guidelines and suggestions aren't relied upon by the agency to require or prohibit certain actions by the regulated parties. So if OCM recommends specific carpet colors for a cannabis business, but does not base any license approval or make any regulatory decisions, such as a fine or suspension, based on a business choosing to follow or ignore those recommendations, that would not be improper and would not be subject to judicial challenge. So where does the rulemaking authority for OCM come from? Well, House File 100, which is the bill signed into law by Governor Walz on May 30th, did a lot of things. One of the biggest was the creation of a brand new chapter in Minnesota statutes, Chapter 342, which is titled Regulation of Adult Use Cannabis, which is, I believe, probably why most people are here. This is the chapter of Minnesota law over which the Office of Cannabis Management has regulatory authority. And Chapter 342 permits OCM to, quote, adopt rules to implement any provision in Chapter 342 using the, quote, expedited rulemaking process found in the Administrative Procedure Act. And while the authority there uses the word expedited, that word, and I want to emphasize this, really only refers to the shortened list of legal procedural requirements that OCM must follow to have the rules approved by a judge at the end of the process. Most notably, unlike standard rulemaking authority, OCM will not be required to post an initial request for public comment prior to the rules being drafted. OCM will not be required to draft what's referred to as a statement of need and reasonableness, sometimes referred to as a SONAR. And OCM will not be required to hold a public hearing before the administrative law judge before the rules are approved. And while that does relieve OCM from some procedural requirements, it does not reduce the real burden that OCM faces when getting the rules ultimately approved. And that burden is the development and drafting of the tremendous amount of rule content that the legislature has directed us to. And due to the sheer scope and complexity of the rules subject matter, which I'll address in a moment, OCM recognizes that the process will require significant consultation and input from those outside of OCM, which is why OCM is committed to a robust and ongoing public engagement effort with subject matter experts, stakeholders, and the public. So while OCM is not required to collect initial comments or have a public hearing pursuant to the expedited rulemaking process, the nature of this rulemaking effort demands that the OCM conduct outreach and engagement for practical reasons. So the upshot of all of this is that even though the process requirements have been slightly pared down through the authority to use the expedited process, the realities OCM face in drafting the adult use cannabis rules necessitates a timeline that takes us into 2025. And this aligns with the legislature's July 2025 deadline for the rules publication. So in discussing authority, here's a small subset of explicit examples where the legislature has directed OCM to fill in some regulatory gaps in the adult use cannabis law through rulemaking. For licensing applications, The legislature recognizes there needs to be forms, but it leaves the development of the actual forms detailed on the required content on the applications and identifying the required procedure for applying to OCM. So those will have to be done by rule. Agricultural safety practices. The legislature points out that the need for parameters on growing cannabis plants, but leaves the details on the actual requirements for plant certification and the testing and labeling of cannabis and hemp plants to OCM. And that is in consultation with the Department of Agriculture, all of which must be done again through approved rules. Environmental standards, details on how businesses must use water, deal with plant waste, control odors, energy use limitations. All of these must be established via rulemaking, and again, sometimes in consultation with a different state agency. And these are just a few specific examples of how these regulatory gaps and discrete rulemaking directives appear throughout the new Chapter 342, which is about 150 pages long. In fact, a rudimentary word search of that law shows that the words rule or rules appear 94 times in Chapter 342. And here's a non-exhaustive list of the general topic areas where OCM will be required to draft rules. But just to expound a little bit with some specific examples. For manufacturing, among other things, rules must be drafted to establish sanitary methods for handling production and what types of equipment are permitted in a manufacturing facility. For retail, the new law says that any retailer selling cannabis products must comply with security requirements established by OCM, including, but not limited to, requirements for maintaining video surveillance records, using specific locking mechanisms, establishing secure entries, and the number of employees working at all times. Again, those details are going to have to be established in rules. Packaging. The new law says that packaging must be child-proof, but rules will have to address what specific types of packaging are adequate to meet that general standard. For labeling, the law requires cannabis products to have labels that state what dosage is, quote, medically safe, end quote, within a 24-hour period. And OCM will have to research and establish what that standard is and rule. For testing, OCM must establish by rule the acceptable limits of contaminants on cannabis products. We have to determine what an acceptable level of lead is for cannabis flower, or what an acceptable level of pesticide residue might be for edibles. And these are just some of the complex issues that OCM will have to address and have approved by the rules. In sum, these examples illustrate the breadth and complexity of the rulemaking task that OCM faces. Not only has the legislature left it to OCM to address many practical requirements of running a cannabis business in Minnesota, OCM must also draft rules that have serious public health and consumer safety implications. And this highlights why OCM is so committed to engaging in outreach to subject matter experts in a wide range of areas, as well as to prospective business owners, current state regulators, and members of the public, all to make sure the rules meet the law's requirements, and also to meet our ultimate goal of establishing the best cannabis regulatory program in the country. But it is a big task, and it will take time. More immediately, however, the vast rulemaking delegations given to OCM demonstrate why it is legally impossible for OCM to issue cannabis business licenses or regulate cannabis businesses until the rules have been completed. The legislature has required that OCM go through the rulemaking process and everything from business application forms to what packaging and labeling must be used on products to what records a cannabis delivery service must maintain, to lab testing parameters. And all of this has to be drafted in rule and approved through the rulemaking process. And until the rules are approved and published, the OCM has no authority as to so much as post a business application form on our website. Which brings us to the actual process we have in front of us and what we've identified as a realistic timeline. OCM has already begun identifying subject matter experts to consult in the many areas that rulemaking will require. We are also in the final stages of hiring a consulting firm with experience working through this process in other states. Beginning in the fall of this year, OCM will kick off a robust and concerted outreach effort to collect feedback on rules and development. As I mentioned earlier, this is not required in order to have the rules approved for legality by a judge, but we believe it's necessary to make the rules better and more well-informed. We expect that the drafting and consultation portion of the rulemaking process will be the most time-consuming element, and a realistic time frame is roughly 1 year until OCM has a complete set of draft rules ready. Before submission for approval to a judge, the Minnesota Revisor of Statutes is required to approve the form of the rules. Given the large set of rules that we will be submitting, we are allowing for ample time for this part of the process. We plan on meeting with a representative of the revisor well before the rule's actual submission to ensure that this step goes as smoothly as possible. In late 2024, as required by law, the OCM will publish the Notice of Intent to Adopt the Adult Use Cannabis Rules in the Minnesota State Register, along with a copy of the proposed rules. And immediately following publication of the Notice of Intent to Adopt the rules, OCM is required to allow written public comments on the proposed rules for at least 30 days. It is our hope that most of the broader and more serious concerns and questions around the rules will have already been considered and addressed through our ongoing public engagement efforts. But this will be a final opportunity for parties to comment and suggest changes or note what they do or do not like about the proposed rules. The law permits OCM to make final changes to the rules at this point based on the comments provided. Following the 30-day comment period, OCM is required to submit the rules to the Office of Administrative Hearings for review by an administrative law judge. In addition to the rules themselves, OCM will address and respond to the concerns or suggestions raised in the public comments. The judge will examine the proposed rules. If the proposed rules fit within OCM's rulemaking authority, review whether OCM follows the proper provisions of the Administrative Procedure Act in developing the rules, and the judge will also look at whether the proposed rules meet their statutory objective. The judge has 14 days to decide, and the judge may approve the rules in their submitted form, offer suggested or mandatory changes to them, approve a portion of the rules, or reject the rules. If necessary, OCM will make appropriate edits based on the judge's feedback and resubmit them for approval. Following the judge's approval of the rules as to their legality, the OCM will publish a notice of adoption of the rules in the state register. At this time, the rules become effective and have the force of law, and the issuing of licenses may legally begin. The governor does have the option to veto, but given the amount of public engagement and messaging that OCM is committed to having, we do not anticipate this being an issue. So what does all of this mean in the interim? Well, until OCM has had rules approved and has begun issuing licenses, it does not have any practical regulatory authority. Until 2025, as discussed earlier in this presentation by Chris Tolkas, the regulation of low-potency edibles lies with the Department of Health. And until OCM begins issuing licenses, operation of any type of cannabis business is against the law. Any other type of cannabis business is against the law. So for those interested in getting updates on rulemaking, including ways to engage with OCM on the rulemaking process, there are some ways listed here. The Office of Cannabis Management website will have information as it becomes available, and currently there is a link to sign up for rulemaking updates. Beginning this fall, we will schedule and publicize public input sessions, which will likely take various forms, both in person and virtual. We will also make available opportunities for topic-specific consultations on discrete areas of the rules that require it. We're developing a form for anyone to submit feedback on the rules as they become available for review by the public, and that should be made available later in the year. And finally, as noted previously, the law requires us to allow 30 days of public comment on the proposed rules when they are nearly ready for submission to a judge, sometime in late 2024 or early 2025. This concludes my portion of the presentation. Thank you very much for listening. Looking forward to the collaborative process and getting started on actually drafting the rules. And at this time, I'll turn it back over to Charlene Briner.
All right. Thanks, Chris, and thanks, Chris Thokas. That was a lot of information. We also recognize that this is information going out. It is not the kind of dialogue that we anticipate having in the weeks and months ahead once we actually launch rulemaking. And so I would just reinforce what everybody has said and what I've said a few times. Please sign up if you are interested in following or participating or providing input on rulemaking, which is really going to be where the bulk of this work lies, at least for the foreseeable future. Please sign up. There is an opportunity for you to sign up for a listserv, an email listserv, which will give you updates. We'll be posting a little later once we have it all put together and well before we launch the actual rulemaking conversations. We'll be posting a calendar so you'll be able to look. We intend to have large public meetings online and virtual and submission opportunities, as well as smaller topic-specific conversations on everything from product labeling to licensing to social equity provisions and considerations that will inform how we look at some of the license applications. And so there will be plenty of opportunity, and we really will be looking to people who have interest, experience, and a vested stake in making sure that we do this right. I actually didn't forward this. The most important thing is thank you. As I said, there is a huge amount of interest in the work that we're doing, both this early work and the ongoing work that will take place throughout the remainder of 2023, 2024, and early 2025. If you have questions, continue to submit them to our website. And I think the final thought that I would leave you with is that we did give you a lot of complicated and detailed information, but the overarching principle and the operating focus that we have sort of put together as an implementation team is that as we go through this process of rulemaking, we really want to keep in mind our belief that the best route to compliance and regulatory assistance and is really by providing support and assistance on the front end, right? We are not interested in a heavy-handed sort of approach to regulation because we believe that working alongside people who really want to do this well and are really interested in entering this space is to make sure that we're very clear about expectations and how you can operate within this regulated market in a way that creates success for multiple people and individuals who've not had the opportunity before. So we'll continue to engage in more proactive outflow of engagement and information, and we also look forward in future meetings to a more conversational opportunity for those of you who have a lot to offer for us. And with that, we're going to end this webinar. I would remind you it will be posted on the OCM website within the next few days once we run it through the process for accessibility. And have a great night, everyone.